So the Canadian Bar Association National Immigration Law Section was appearing before the Standing Committee on Citizenship and Immigration Canada, examining Section 38(1)(c), medical inadmissibility provisions under the Immigration and Refugee Protection Act. The elimination of categorical presumptive exclusions for certain conditions that would affect persons with disabilities primarily. Secondly, we also advocated for immigration officers and medical officers to perform their distinct functions in making medical and admissibility decisions. And we also argued that procedural fairness letters should be drafted in plain language with an update to the Immigration, Refugee Citizenship Canada website, as well as advocate for independent legal advice on those procedural fairness letters, all with a view to make it easier for applicants to engage with the department and go through the mitigation process at in a much more inclusive and fair manner. So there's a number of advocacy groups as well as individuals that are actually arguing for the repealment of the entire section. They feel that it's discriminatory and not charter compliant. Our position is that if properly applied, it could be charter compliant as well as non-discriminatory. There are discriminatory aspects to the way it has been applied, but the situation has improved tremendously since Hillowitz in 2005, which was a Supreme Court of Canada decision, which was led by many CBA members, including the late, great Cecil Rotenberg QC. So we've put in our briefs, we've testified as to our position today. There are some follow-up questions that the committee has asked of the CBA, and we'll continue to engage in the process until they finally make their recommendations. And at that point, once the committee makes their recommendation, we will likely comment further.